Hi, I'm Gul Virk, your host and founder of Canadian Law Tutor. I'm your teacher, friend to understand contract law exam today for your NCA exam. So, what is contract law? Have you studied contract law earlier? We know that contract law is most logical subject out there. It's just understanding of the subject and applying the standards and applying the concepts. So when we look at the contract law syllabus, back home, if you're from a common law country, you will see that, you would see a subject coming from acts and stuff. We are learning, oh, this is the law, this is the, contract law, contract act, like what my introduction with contract law was in my first year of LLB, and it was Bachelor of Laws, and there was a subject decide given as contract law, and it was Contract Act 1872 back home in India. I did it. But over here, when we look at the contract is everywhere. Real estate is contract. Even every other country, the contractor is everywhere. But we are trying to understand contract law is a subject which is about the application of the contractual principles. So, contract law is about application of contractual principles on situations relating to different practical scenarios. You apply your knowledge and your understanding of Canadian contract law. So, how do we see what the contract law is? So, first of all, we will look at the syllabus, what the syllabus is telling us. So biggest thing we have is the formation of contract. In contract law, I will always see who is, in your picture, who is on the other part of the contract. How would you say that you have a contract with somebody or not? Only the first thing and the foremost thing to identify in every situation is to see with whom you have a contract, right? Supposing A and B are in a picture, they negotiate, and B tells C that if I have contract with A, then I will send it to you. For example, I hire, say, Komal, I hire you to review grammatical mistake in my notes or something like that. And then you promise somebody else, like when Gold pays me for the review of my, this project, I will be buying this thing from you and stuff. But somehow I got a better offer from Jaspreet and I hired her to do that job. And then the guy with whom you promised that you would be doing it, he comes and sues me and say, hey, Cole, you never complied with your promise with Komal, and now I'm hereby suing you. And I'll be like, I what? What would should happen in this situation? So contract law, the first thing that we would see is who is a privity of contract, who is part of a contract. If you see contract law, of course, in law, we have exceptions. There are situations when people who are not privy to contract would be able to sue, and that would be a subject of a proper class learning more in detail. So, right now, where we are sitting, we are looking at a contractual provision. So, in contractual provision, the first and foremost thing we are trying to welcome Sana. Welcome Sana. Welcome Aman.
Thank you, ma'am.
Welcome to my contract law webinar. So, are you guys writing this subject? Or you're just here to know about NCAs and stuff?
Well, I haven't given my assessment as of yet,
Hmm.
but someone had told me that I might get contracts because my marks in contracts are very low.
And may I know from you from which law school?
Yes, I finished my LLB from Cardiff, but I did my schooling from Canada. Like my parents are from Canada, but I did my LLB from Cardiff.
Wonderful. So, okay. So, but you should be hearing from NCA soon, right?
I they sent me an email recently. They said that it'll take them around 8 weeks to do my assessment, but I have given them all my documents.
Okay, it's wonderful. No, it's never too early to start learning. There's no
No,
such thing.
absolutely.
There's no such thing as too much learning.
I completely agree with you.
Yes. So we have basically, as if there is anybody who is from a civil law jurisdiction, please let me know so that I can, add more information and put things in context, because I would be assuming we have common law understanding in this subject, and so that we would be going from there. Hello, Aman.
Hi there, can you hear me?
I can hear you perfectly. So you're writing contract?
Yes, I am.
Wonderful. So, contract, the first thing we are trying to talk about the syllabus, and the main thing we are talking in the syllabus is this concept of formation of a contract, correct? So, here is your syllabus, and this is your page 3, and this is about contract formation of a agreement. So, I was saying the way I have studied contract law, we had an agreement and we were just a contract act, and we were just learning the basic features of contract. Like there is an offer, there is an acceptance, whether there's an offer or acceptance and stuff like that. But our NCA contract law exam is something more than that. It's about understanding the contractual provisions and applying the contractual provisions as the rules laid by our Honorable Supreme Court of Canada, to see whether a contract is formed with somebody, whether contract is enforceable in a situation, or what are the escape routes from a contract law. If we break down the contract law into the bigger concepts, it would be who is part of the agreement, correct? If you remember in maths, we used to have a basic concept called board mass. In that we had a bracket, right? Then another bracket, then another bracket, another bracket. So we will solve those brackets as we go along. So in contract law, the first thing we will see is understanding the basic bracket. So the first bracket, who is part of that agreement. So if you are in this, we are in this call, and there may be other students who just want to join, or they just come to know about that. So they may not be able to come into the main loop of our discussion at this level. So in the same way, when we try to apply it into the contractual provision, we will see that the formation of the agreement requires you to identify who is the party to an agreement. So I was giving an example with Komal and Jasprit, that Komal entered into an agreement with me to provide me some notes, some resources. Didn't, I did not comply with that agreement. I went ahead and get the job done with Jasprit. So at that level, anybody who was dependent upon the benefit of that contract with Komal, can they come and sue me or not? Then we will look at the principle of privity of contract. So in the contract law, the first thing we will see, formation of a contract. If there is an agreement in the picture or not. If the agreement is there, then who is party to that agreement? And that would be covered by the principle of privity of contract. And the next thing we have after privity of contract is seeing what are the exceptions and stuff. So before jumping into the exceptions, before jumping into the concept of applying and having everybody coming into the main picture, you have to see that who is party to a contract. So the first and foremost information you're looking in any scenario is, or even when you're reading the resources and the case laws, in your own understanding, the first thing you will identify who is party to the agreement. If somebody is in parties to an agreement, are they going with the agreement, or you're trying to opt out of the agreement, or they're trying to just are the deal breaker? If those guys are deal breakers, what are the components given in the deal breaker? So it can be a clause coming from a contingency. I said I will so Komal, it can be contingency, can be I will hire you to review the notes, or we will go with the agreement only if NCA offers this particular course in January. So that would be a contingent clause, correct? contingency, it's dependent upon something. Or it can be uh, a representation by you would say, oh Gul, I would be providing you this these notes in French as well, correct? So in that situation, you are giving me a representation. So we will look at the deal breakers, deal killers in the situation. So contract law, end of the day, is a deal, whether we have a deal or not. If we have a deal, how this deal can be cancelled and how this deal can be enforced, right? So who are party to the agreement? The contract law, the basic understanding of the subject is applying your understanding based on common law. And now we are looking at Supreme Court of Canada, laid down principles in different scenarios. They have given us a guideline to apply the Canadian contract law in this situation. So the next big friend we have in this situation, the best friend throughout your process, is not your tutor, not anybody else, but rather you have Supreme Court of Canada. That's your best friend. The best resources to learn Canadian law in this SCC website. Over here you will see the judgments, and you will see the summary of provided by SCC is amazing, and you will see how they have given the breakdown of this subjects. Let me take you through so these are the reasons only. Anybody have any questions with me so far? Basic purpose of our understanding on today's webinar is to give you tools to self-study the cases, self-study the subject. So the first step I have for you is always apply the basic understanding. Remember, try to see the agreement, or if you're doing taught, try to have a bigger picture. So you can even do it on a A4 sheet. Draw yourself a guideline, a memory map to see this is what the agreement is. These are the parties. These are the deal breakers. These are the escape routes. So that have that sheet on your notice board in front of you all the times. That is the best way to stay grounded in the studies. So the biggest concern we have in the exam is like we cannot yeah, that's very nice. Mind maps are very helpful. So always try to see what is the bigger picture. If we look at the contract law, end of the day is who is party to the agreement or disagreement, whatever is working or it's breaking. If it is breaking, why it is breaking, and what are the options to the person who want to opt out of it, and what are the legal requirements of a valid contract. So that's how we will study the contract law, study it in more depth, and try to have the syllabus in control. And whenever you take any resource, make sure you confirm your understanding with Supreme Court of Canada judgments. You go read the summary and see how it's been interpreted. Reading those, you won't be dependent upon then on any IRX or anything, because you are yourself a walking, speaking IRAC machine. You can print IRAC wherever you want, because all you need to understand is understand the approach. How do you understand the approach to deal with it? Look at this analysis. So basically over here they are saying the duty of care. So we have do we have a volunteer over here to read? Aman, would you like to read? Anybody else who would like to read with me on this one? So over here, the basic question we have is the framework for duty of care, how it is being played and under this thing. So Jaspreet, Sena, Komal, anybody to want to read? So I'll read. So please see. Uh, if you want to read, you're more than welcome to start reading here. From here. In Martel Building Limited, Canada.
In Martel Building Limited v. Canada, this court left the door open to a duty of care arising between subcontractors and an owner. Finally, we note that Desjardins J.A. relied on two cases to support the view that a duty to treat all bidders fairly and equally had been recognized in the context of tort claims. However, we note that both cases have subsequently been reversed by appellate courts. Twin City Mechanical v. Bradsill.
We don't need the cases come. In addition,
Okay. In addition, reliance in tort was necessary because both cases involved situations where a subcontractor sought redress against the tender calling authority who had received bids from the general contractor. Since there was no privity of contract between the subcontractor and the owner, liability could only be founded in tort. In both cases, the appellate courts refrained from deciding whether or not a duty of care was owed in such situations and preferred to limit their decisions to the fact that a breach could not be established. We believe that the issue of whether a duty of care can arise between a subcontractor and an owner must be left to a case in which it arises.
so as you
Emphasis.
yes, so as you see,
This is such a case.
pardon me. Yes, now calm down and read this para 26 with me.
Proximity has generally been understood in the context of an overt act that directly causes physical loss to a plaintiff. However, the notion of proximity has been extended to cover certain limited circumstances in which a defendant, without causing a plaintiff to suffer personal injury or property damage, did cause financial loss to the plaintiff. Further, Canadian law recognizes that new categories where a duty of care is recognized may be established by application of the analysis set out in Anne's v. Merton London Borough Council.
Period. Now we are learning over here that in contract law, end of the day, enforceability and liability is basically depends upon who is party to the agreement, correct? Privity of contract has its two small exceptions, which is given in our syllabus, and we will be, in our proper classes, in more in-depth detail, we would be discussing and learning those two exceptions. But right now, for the argument's sake or understanding sake, and the bigger picture of this subject, we can say contract law is all about, the first thing is it's not like an open-ended discussion. We are not, this is not like constitutional law matter which everybody would have a say. No, contract is a closed loop subject. The first closed loop in the agreement is the party to the agreement is. So we have to see who is the party to the agreement and identify it, and then see what are their options in the situation. Just because, there are 20 people who are inquiring about my classes and 20 people who are, another 40 people who are asking me about the notes, and another 50 messages which I'm, receiving on Facebook. That's just a business information exchange. That is not a contract. Contract would be people who are actually signing up for my courses and doing courses with me. So the first thing we have to identify in the contract law is the parties to the agreement. And the next thing we will be learning about this is how this agreement can be violated by somebody. If somebody has violated the agreement, there was a breach of an agreement, or there was a inducement. Supposing in the beginning I said, oh, I teach NCA courses, all NCA courses, and and explain it uh, really well. But end of the day, we learned that Sana was just looking for learn in French. She's writing NCA exam in French, right? If I told her, if she asked me like, do I teach in French as well? I would say, yes, I teach in French as well, right? But that would be a misrepresentation. So Sana would have an option to opt out of the agreement based on my misrepresentation. When she spoke to me, he spoke to me, he figured it out. Oh my God, she doesn't even have a dutre. She doesn't even know anything about French, right? So she made a misrepresentation. So misrepresentation is played like that. So sometimes it can be like that. I start teaching NCA courses, the subject, but I had no understanding of the fact that Sana is looking to learn in French. She said, do you too teach? I said, yes, I teach. So in that situation, there is a you can say the agreement cannot be worked the way it should be. Then the agreement would unwind because we both had a mistake in entering of the agreement. So the mistake would be when he believed I teach in French and I believe he just need to understand, and so normal, like other students, he just need my help in English. So that would be a mistake and it would unwind the agreement. So let's put an example of frustration. Supposing, let's say we were sitting in March 2020, and in that case, you all signed up for my classes. You all learn only in a best way for learning for you is to sit in class in person scenario and learn it, right? So then the COVID happened, and then we cannot no longer meet in person. I said, oh, I'm gonna switch my classes to online platform, and one of you said, oh, I cannot learn in a digital format. It's better for me to on a digital platform. I only learn in person, but due to COVID I cannot meet you in person, so that would be a frustration of a contract. So that's how you see, when we start learning the subject, we will use the practical scenarios, practical understanding, and then we'll use the case laws and see how a particular situation leads to a different outcome in a contractual provision. And then we will apply the guidelines laid down by Honorable Supreme Court of Canada for our application in our country. Then we'll see whether this can actually goes to that standard and can be broken down in that level or not. So this is basically your application. So my purpose of today's webinar is to give you, an understanding. And if you want to have a start self-studying on for this exam, you should, have some tools to apply in your self-studies. So your first thing to apply is understand your first best friend you have is your subject, is your syllabus. Make sure you read your syllabus thoroughly. It may look overwhelming, so I would say just take one concept, then read the cases. After reading the cases, make sure you come back to your syllabus once more, so that you have a better understanding what they were trying to ask you at the first place. And then we would say, always confirm your knowledge. Even if you don't are not reading it as the main source, I would highly recommend you to have Supreme Court of Canada website as your best friend throughout the process. And the next thing I would say in this situation is, if you are not reading it at the first place, you are using some other resource, come back to it and make sure you confirm it. Once you have read it, read it from here, you will see how wonderfully the law has been laid down, and you can confirm your understanding with this, so that notes or any other resource can be shortcut or a summary of something, so you would be able to confirm your knowledge and apply in a more comprehensive way. So Aman, do you have a question for me?
No, we're good as of now. Yeah.
Okay, so Mandeep, do you have any question for me?
Not yet.
Not yet. Okay. So this is my basic introduction for the subject, so that when you start studying on your own, or you decide to take take the classes or anything, you should know how the subject has been broken down, how the subject has been, is required to be understood. So every subject needs a little bit of different approach of understanding. So you're all, don't worry about your common law, understanding of contract law. It's all there. Agreement in your contract law exam is, of course, is a legally enforceable promise, right? So all the things which you learn in your basic law courses would apply here. But the next thing over here you will learn is little bit understanding more in depth how different situation the Supreme Court of Canada has given us guidelines, and common law understanding have evolved in our country in a little bit different way. Yes. So this was my basic introduction about this subject, so that when you when you start your own studying, you would have some tools to apply, some basic information to apply in your self-study. I'm here to answer any question regarding NCAs. So if you don't have a question about a contract law, but you have some other courses, question about my courses or your own subject you are writing, or you have some specific question about the process, I'll be happy to answer. I'm running contract law classes as well. You're more than welcome to join. I'll be posting the schedule in the group. But I would highly recommend you to do your self study with the more empowered way, having your best friends, all the resources and understanding, and feel free to reach out to me for any questions you have as you are going along the line.
Hello. Yes, this is
Hi.
Aman. I think there was someone else also speaking, so I'm just going to go ahead and ask my question, and then the other person can ask. So, first question is that for contract law, IRAC is the suggested method of answering questions.
Yes, IREX is these are application break questions, and practical scenario based question. Of course, there would be IREX.
Okay. And secondly, what I noticed is that when I was going through the syllabus is a very detailed syllabus.
Mhm.
So this is something that I found out was common when I prepared for the foundation exam also. So having a copy of syllabus is a must when I'm writing the exam. But apart from this, do you feel that our own notes that we prepare from the book that should be sufficient?
Of course, that should be sufficient. Your own understanding, the way you understand subject, is the thing which you need to demonstrate it to the examiner in the exam. And of course, it's a very good way of studying and very good resource.
Okay. And usually speaking, how many questions do they ask in this exam, and are they all questions which are based on an example, like practical based questions?
They are all practical based questions, and there can be 4 or 5 questions, and you will apply your contractual law understanding on that.
Okay. And as far as your experience is concerned, maybe not right now, maybe at the end of the class, can you give us some topics which are the chances of getting a question on those topics are really, really high?
I haven't studied that way in ever, and my teaching is not based on that thing. Like what is important. If you're looking at a contract law, if you look at one, just think from a practical scenario. If you have a 2-page contract in front of you, each and every para is important, and each and every para has an ability to kill the contract, right?
Absolutely.
Yes,
Yes.
so I would not go that way and answer that. I've studied everything, and I would see like overall understanding and demonstrating, because in the exam it's more like a puzzle. How do you solve a riddle with your understanding, right? If you don't demonstrate your understanding in the comprehensive way, the examiner will think that you never understood the subject. So you should read, not have to, there's no have to, you should read the subject thoroughly, understand, so that you can demonstrate the proper understanding. Yes, anything else?
No, I think this is
So we are,
all that comes to my head right now. Yeah.
yeah,
Yeah. Thanks.
wonderful.
Thanks so much. Yep.
Go ahead, please.
Hi, Gul, Angad this side.
Hi,
Gul, just
Angad.
one. Hi. Just one question. In terms of reference materials, you refer to the SEC website, and the syllabus mentions Benny Shire's books and McDowell's and Vedant's.
Right.
Apart from that, do we have any specific statute also to kind of refer to? Or, I
Yes,
mean,
there are certain statutes. Like, for example, we will be required to understand in contingent agreement, we will be going through real estate agreement. So the way
Mhm.
I teach is I would bring all few agreements so that you can see how the clauses are played in the practical scenarios. And there are certain statute. They are not top of my head, but there is one thing. I think in point number 11. But no, I will show you where it is. Give me 1 second. It about the somewhere here. It's about the timing. There's an agreement, and I think that's section 11. Yes, yes. Electronic Commerce Act,
Okay.
2002. So it's about emails. So if I send you an email, I'm supposed to send you an offer via an email, and that's you do have there is an evidence that you have there is a presumption that email is read in 2 minutes.
Okay. Okay.
But if we are talking about a person who uses a library computer, and then he would have an exception. So remember, we have a postal rule and agreement, contract law for 5 days or something like that. We had a postal rule, so this is an exception to postal rule.
Okay. Okay. So we do have certain reference statute
That's reference.
references.
So I highly recommend doing certain agreements in my courses. I take a practical agreement and play it with in the class, so that we can understand how, because it's not just the purpose of this agreement. At the end of the day, we are all working in the practical legal field. So the understanding of the subject is not just to pass this exam. So I invite contract law or real estate lawyers to come and talk about the key concept of the agreements as well, and the bindingness or the enforceability of the agreements.
Right. That helps. That helps.
Yeah,
Thank you. Thank you.
my pleasure. So I hope everyone takes some more information, feel more equipped and more organized in your studies, and I hope it helps. If you have any suggestion for my classes, any queries about the law, please feel free to reach out to me. And happy studying for contract law.
Thanks. Thanks, Gul. Just to reach out, you'll be sharing your schedule in terms of your classes and your
Right,
materials.
I would be definitely sharing my schedule. And if you have any question, please reach out to me. And I'm gonna. You have my phone number from WhatsApp, right? So see,
Yeah.
I'm
Yeah.
just going to give you my phone number. So you have my
Definitely.
phone number. So we'll take it from there. It's so
Yeah.
nice to see you, Jaspreet, Komal, Mandeep, Mr. Sheikh, Aman, and Angad. And I wish you good luck for your studies. And please let me know, keep me posted about your legal journey. It'll be like so exciting to see where you are going in the, uh, you know, in your legal field. Thank you very much for joining on this Sunday morning. I hope you enjoy your pancakes. Pancakes with wonderful coffee, and gear up your studying. Happy studying from Canadian Law Tutor. Thank you very much.